What's up, everybody? What's up, everybody? Welcome to the live. Welcome to the live. Let's see how many people we can get in here. If you're watching, you just tuned in to my live, give me a subscribe, hit the like button, let everybody know that we're here. This was I didn't plan this one out. I've got a YSL trial update I'm doing this afternoon with Doug Weinstein here pretty soon, but this is about the Tory Lanez appeal. The state attorney general's office has responded to Tory Lanez's appeal in his convictions for shooting Megan Thee Stallion in his 10-year prison sentence. So I've got, there's actually a couple documents to describe. I'll get into the process here, but just want to make sure people know that the YSL trial update, there's so much going on, but I'm gonna keep them separate. This is going to be all about the attorney general's office responding to Tory Lanez's appeal. If you somebody says they're sipping out of their googly-eyed bitch mug. Thank you so much. And that's a good reminder. I need to get the store linked up on YouTube. There's so much to do with that. You've got to get the photos all right and that kind of thing. But if you guys go to MeghannTheReporter.com, you can get some googly-eyed bitch merchandise yourself. But there's no decision on Tory Lanez's appeal. The news is the Attorney General's office has finally filed their responses to his argument. So it's the first time that we're able to hear from them on this. If you go into the description on this video, you can see a link to my article on it, and it's got the document in there. Let me put it in the chat here too, but I'll bring up my article here. And thank you guys so much. Kirby JM, thank you so much for your support. But this is a response to the one that I wrote about. Was filed on Friday, and this is a response to his habeas petition that's all about the driver's supposed new statement. The habeas petition was filed in December. I did an article on it then. You guys might remember it. It's still on my website, but I've got the driver's statement linked in the new article. Everything. Good evening, Black Butterfly. Thanks for tuning in. Everybody hit the like button. Let the algorithm know we're here. This is a little bit different, short notice surprise and not a YSL trial update. I'm going to be doing that later with Doug Weinstein, but this is all about Tory Lanez's appeal in the state attorney general's office response to it. I just published an article about a filing from Friday that responds to his habeas petition. And now it's a little confusing, but there's two cases to track. And this is the habeas petition that's all about the driver's new statement, and it was filed in December. So the attorney general responded to that on Friday. I got the filing, but then also today, the attorney general's office has responded to his main appeal, and that was just filed. Excuse me. I don't have a copy of that yet, but I should be getting it pretty soon. The PIO's office there at the Court of Appeal is pretty good about responding stuff. It's just they get the emails and respond within a couple of hours, but there's, two different filings. So I got the one on Friday and put together an article over the weekend to sum it up. So yeah, thank you, FT. Everybody hit the like button. Let everybody know we're here. Get the news out about what's going on here. But thank you guys for tuning in. But again, this is the state attorney general's office basically responding, and it's called an informal response, which for a habeas petition, they're arguing that his arguments, as assumed to be true, don't present an initial case, that the attorney general's office should summarily deny his petition based on this, which if the court disagrees with that and says, no, the facts as alleged, if assumed to be true, do establish an initial case, that's not a finalization. It would mean there would be another step in order to show cause or some kind of other evidentiary step that would lead to more analysis there. But the first one is just an initial, does this meet an initial first impression? And the AG's office is saying no, that they should deny it. But again, this is the Attorney General's office responding to Tory Lanez's appeal, and their main argument in his habeas petition the state attorney general's office says that Tory Lanez's driver's statement that's supposedly new is not actually new, that Tory knew about how the driver would testify during the trial and opted not to call him as a witness. And we've always heard that the driver didn't testify because he showed up to court, and if he was to testify, the prosecutors wanted a few days or time to prepare for his testimony that would possibly delay the trial over the holiday and lead to a mistrial. So they decided not to call him. But the Attorney General's office, when drafting their response to this, actually got a copy of the transcript for an ex parte meeting that Tory's lawyer had during trial with the judge, in which this is George Mgdesyan, explains why he wasn't going to call Quan as a witness. And it says in here, they actually quote from it, and it has George Mgdesyan saying, "We came to the conclusion that we're not going to call him because obviously his testimony is going to be putting the gun in the hands of Kelsey." And that's what he told all of us when we just did an interview upstairs. At this point, my position was that the jury believes our theory. I think Sean Kelly already put the gun in Kelsey's hand. And if they're really going to believe that he took the gun from him and you started to shoot it yourself, to me, it's kind of an absurd argument. This is George Mgdesyan talking, and he and yous are a little hard to understand, but he's talking about Lanez. Just basically, he's saying he thinks the jury already believes the theory and that Sean Kelly's testimony was enough to support it. But remember, there's always different reasons for not calling witnesses. And one thing to keep in mind here is the cross-examination. I mean, a lot of the times, the reason we don't actually hear from witnesses is because it's not the direct examination that's the problem. It would be the cross-examination. And I'm sure the prosecutors in cross of Quan would focus on his, at least in part, on his claim that he didn't actually see who fired the gun, because that's not really a believable statement from somebody who's just was standing right there and saw the whole thing. But it also could be possible that, what did he see immediately after that kind of thing. But he'd be subject to all those kind of questions in cross, and it might not end up going well. But this is the first time we've seen the transcript from this meeting that Tory's lawyer had with the judge during trial that explains why he wasn't going to call Quan as a witness. And it completely contradicts the current argument from Tory's new lawyer that nobody knew how Quan was going to testify, because in the habeas petition that was filed in December, that's blatantly what it says. It has the new declaration from Quan saying he didn't see who fired the gun, but that he saw Kelsey with the gun, and Tory was struggling with her over it, that Kelsey and Meghann were fighting, and that Kelsey had the gun. So when this was filed in December, it's part of this habeas petition that says this is new evidence that warrants a new trial. And the habeas petition acknowledges that they, of course, knew of the driver and his possible testimony, but it says in there that we didn't know how he was going to testify until now. And the AG went and got the transcript from the ex parte that basically just shows that isn't true. I mean, here's George Mgdesyan saying exactly how Quan was going to testify and saying that he doesn't think it's necessary. So that pretty much shoots down their new evidence argument that, somehow Quan's statement constitutes newly discovered evidence that they weren't able to have during trial. So that's the main argument in the petition, but there's some other stuff too. Here it is. But again, this is the state attorney general's office responding to Tory Lanez's habeas petition, seeking to overturn his convictions for Megan Thee Stallion and also to vacate his 10-year sentence. So he has various arguments in there, but the biggest one is about the supposedly newly discovered statements from the driver who didn't testify. And they're saying it, and this is the AG's office explaining why it doesn't constitute new evidence. But they also get into that they didn't show that if Smith did testify, it would more likely than not change the outcome of the trial. And it calls the evidence of Lanez's guilt compelling, says Megan's testimony that he shot her is supported by, quote, by a wealth of other evidence, including Harris identifying him as the gunman in texts sent moments after the shooting. Those are the texts she sent to Megan's security guard the moments after the shooting in 2020 that said, "Help, Tory shot Meg, 911." So, and then they also mentioned the recorded interview with prosecutors before trial. And then the filing says, although Harris failed to confirm the identification at trial, she remained consistent with respect to her denial of having been the shooter. Moreover, within minutes of the shooting, responding police officers found the gun used to commit the shooting under the front passenger seat where petitioner had been seated when the SUV was stopped. And then it says Lanez also implicated himself as the shooter twice in recorded statements made within 24 hours of the shooting, Keller wrote. And he doesn't specifically say what it is, but he's obviously referring to the text messages that Lanez sent Meghann right when he got out of jail, and then the phone call that he made to Kelsey from jail that was recorded. And he doesn't specifically apologize for firing a gun or any kind of shooting in there. But during the closing argument, I remember the prosecutor in trial went over how line by line through the phone call and just said there really wasn't anything else he could be talking about. But Lanez argued in trial, his lawyer did, that he was apologizing for sleeping, having a relationship with both Meghann and Kelsey at the same time that led to Harris shooting Meghann. But it just didn't seem believable. And that call's out there. It's got I've got it linked in here. We could listen to it if we want to, but kind of. I think a lot of people have heard it, but if you haven't, it's linked in there. But and again, this is my article on the brief that was filed Friday, and it's an informal response to the habeas petition that appellate lawyers filed on. I should delete that on December 12th, 2023, that seeks to overturn his felony convictions and vacate his 10-year prison sentence, in part because of alleged new evidence. He wants but Keller wants the second district to determine the petition states no case for relief on first impression or prima facie, and summarily deny it. He filed another brief Monday opposing Lanez's main appeal, and that's the one that I just requested and should have a copy of soon. But a 3-judge panel from the second district is going to consider the habeas brief the same time as the appeal, as well as this motion for relevant evidence that Lanez's lawyers filed in June. That it's related to the sentencing, and it seeks to have the state release statistics regarding the number of people charged with first-degree assault who did or did not receive a gun-related sentencing enhancement. And this is part of her argument that somehow his sentencing enhancement was improper and that he needs to be resentenced. I mean, it's really kind of crazy that, or impressive that, Jose Baez was willing to have his name on that petition, because he clearly didn't write it. And it was Crystal Morgan from Unite the People, but it's really poorly done. I mean, just reading the response to this, I mean, yeah, they don't make a very good legal argument to support any of this. And especially their arguments where they go through and cite all these sentencing laws and act like they should, retroactively apply. The AG's response explains how all of these laws were accounted for during Lanez's sentencing. Like Judge Hereford knew about these laws. Lanez's lawyers during sentencing cited some of these laws. So in this habeas petition, they're kind of acting like nobody had brought up these laws before, but they clearly had. So that's kind of the bulk of it here. But and the motion for new evidence, which is going to be considered the same time as the habeas petition and the appeal, it also seeks information relating to charges, conviction rates, and length of sentences for celebrities of all races. But it doesn't define celebrities, which I thought was strange, but Keller's June 26 opposition and the evidence request said the request is premature because the court must first issue an order to show cause before ordering discovery. So I've got the documents linked down here. This is the motion for relevant evidence that was filed back in June. It's 49 pages, but it's actually it's got transcripts attached or something like that. Or the original filings attached. The new filing is not that many pages, but again, they're seeking statistics from the state, and it's a little confusing, but it's basically just statistics that they think are going to show help establish their case that somehow his sentencing enhancements were unfair. But the state AG, I mean, they must have kind of enjoyed responding to this.